Okay, and I just want to welcome everybody who might be listening. My name is Brian Pryor. I work at the Crime Victim Center of Erie County, and I'm doing this, well, we'll just call it kind of a webinar, podcast, audio Q&A discussion with some really informed people that I feel might be able to best explain the new Title IX regulations and changes that were just recently handed down and what it might mean in the realm in particular of higher education. So I want to give everybody that's here just a chance to kind of introduce themselves and sort of give everybody that might be listening an idea of why we're here and you know, why we want to discuss this issue and why we think it's important. So we'll start with Suzanne Estrella, if you want to introduce yourself.
Sure. My name is Suzanne Estrella, and I'm the legal director at the Pennsylvania Coalition Against Rape. And in addition to providing legal technical assistance for the coalition and the staff at PCAR, I also manage PCAR's Sexual Violence Legal Assistance Project. And on that project, we provide direct representation to survivors of sexual assault, harassment, and abuse who are unable to obtain free legal services in the counties where they reside. So in that role, we have represented students on college campuses who have been assaulted on college campuses and are going through the internal college procedure for justice. And I'm hoping that through this webinar, we'll be able to provide some guidance and assistance and help people to understand a little more what those changes mean, what they could possibly look like, and how legal services could be available to assist them.
Fantastic. Well, thank you for everything that you're doing. Karen?
Hi, my name is Karen Galbraith. I'm the Training Projects Coordinator at the Pennsylvania Coalition Against Rape. And in my role at PCAR, I've had the opportunity to do a lot of work with college campuses around their responses to sexual violence, which obviously includes Title IX guidance and things like that. So I'm really excited to be here on this panel today to, share some of my insight into all of this and also to learn from other panelists about how we think this is going to look moving forward. I also have had the opportunity in the last few years to do some adjunct teaching on college campuses and have been able to sort of get that perspective on Title IX and what this means for students and professors and things like that.
Thank you. And just a quick aside here, I can say that that's good because one of the things that and one of the reasons why I wanted to do this presentation is I was approached by some of the higher education people around in our area in Erie. And one of the top places and one of the top issues that they want to address a lot of this is from the adjunct, because it's not just the students that are going to be affected by this. It's going to be the advisors. It's going to be the educators as well. And a lot of times that adjunct position is one that's kind of, they have just as many questions as far as this goes and their role in it, as well as the students themselves. So, and last but definitely not least, Donna, if you want to introduce yourself.
Sure, thank you. My name's Donna Greco, and I'm the Policy Director at PCAR. In that role, I have the privilege of helping to mobilize PCAR's mission through public policy change and legislative reforms. I'm grateful to work with the network of rape crisis centers in furthering that mission in the state and federal legislative realms. Just a little bit about me is I started as an advocate many, many moons ago on my college campus as a peer educator, trying to help prevent sexual assault and dating violence as an undergraduate. And that's really where my interest in becoming a lifelong advocate began. And I also had a very brief stint as a Title IX coordinator under the Obama era Title IX guidance. And so it's through those lenses I'm bringing some information, hopefully that will be helpful, along with you all here today on the podcast. And thanks for having me.
Absolutely. So once again, just a quick little disclosure. I had some general questions that I thought we should probably address, or at least the most common ones that I saw that were coming up in regard to the changes to Title IX. But I suppose we should probably, as well as we can to whoever wants to, just kind of explain, well, what exactly is Title IX and why might students, teachers, parents want to know exactly what Title IX is and how it applies to them. So I understand that's a huge question, but we can kind of take it as basic as you would like. So
I'd be happy to start with just a general definition. I mean, Title IX is a federal law that passed in the early 1970s, and it's actually a part of civil rights in that it tells schools, whether it's K through 12 or higher education, that they are not able to discriminate against any student based on sex. So sex discrimination is prohibited under Title IX, and it applies to any educational institution that receives federal funds. There's a lot more to it, though, obviously.
I think as I've been spending time over the past number of years doing training on Title IX and just talking with friends and family about it, I think that there was always a lot of misunderstanding of it in that folks were familiar with it as it related to sports and sports teams and sort of didn't understand the broader application and the need to address gender equity in all aspects of education, not just in terms of sports and sports funding and that sort of thing. So I think for me, that's been an evolution that I saw over the past number of years as we saw more attention on responding to and preventing campus sexual assault, that people sort of started to broaden their understanding of Title IX and broaden their understanding of what their rights are under it.
And I can certainly agree with that as well. And I will personally attest to the first time that I had been exposed to what Title IX meant was in regard to equality with sports. So it was a situation where you had this large sort of federal guideline against sex discrimination, but a lot of times when you have a very large law or a guideline like that, it's only when it's sort of first used that you get an idea of what it may mean to you or what it may mean in general. And it just so happened that, I guess, sort of like historically speaking or legally speaking, the first time Title IX was really sort of implemented and applied was to create equality for athletics in higher education. And it's important to understand that while it can be used in that regard, it is sex discrimination, period. If you get any sort of federal funding, you can't in any way, shape, or form create a dynamic on your campus that is discriminating based on sex. So.
Mm-hmm. I think it's important too for students and parents to know as well, especially at the college level, that each university will have their own Title IX policy that you should be aware of. And that's normally found on their website in electronic form, but it's specific to the university. So it's their interpretation of how they are enforcing Title IX at that school. So it's very important for you to know your school's policy and be able to find where that's located on their website and get that information.
Absolutely. And I will attest to the fact that prior to this, this meeting that we're having, I was sitting in on a webinar podcast that was done by a couple of the the diocese universities locally here. And what the issue of that was, okay, these federal guidelines have changed, and we'll talk about that have occurred. But the general idea that at the end of the day, we're all universities that have religious aspects to our guidelines and everything. So how do you take these Title IX changes, our religious idea of a university, and meet the two where we're adhering to the Title IX, but at the same time not losing our identity as a university. And a lot of ways that universities do that is through their mission statements. And Title IX, while it's a federal guideline, all universities, as you said, Susan, will try to take their particular mission statement and take the federal guideline and have them line up. Really important that you understand if you're applying to a university, if you're getting ready to go to a university, if you work at a university, how they specifically look at this. So moving forward, whoever just wants to take it first, what was the biggest change you saw? What was the first thing you noticed from the changes?
I think the first thing I noticed was the change in the definition of what would be considered a Title IX violation. They changed that definition of sexual harassment. I think that's the biggest change. And to me, it seems like it's going to be the one that has the most impact. And that three-prong definition where, and I think specifically the second portion, where instead of just any form of sexual harassment could have been reportable and required an investigation by the school. But now if you're talking about sexual harassment alone, it has to be severe and pervasive. It has to be objectively offensive. And it has to be something that would deny education. So that whole objectively offensive is, that's a big change, because now you're not talking about just that it was offensive to this one person, but kind of like it has to be a standard in the community that everyone would find that offensive. And how schools are going to go about interpreting that, I think, is going to be very challenging. And then the fact that the severe and pervasive, so someone could do something one time that's sexually harassing, but if they only did it once, then the school could argue that that's not a violation and they cannot open investigation just based on this one-time incident. So those are huge changes.
Yeah, and just talking from a bit of a legal background, that's always one of those, I know it still exists, but some terms, you look and you wonder why they're still being used, because the legal aspects of them have been argued and are either disproven or just challenged on such a level that most times you choose a different set of words because there's an issue with them. And to have objective and then offensive, which, you know, the history of the United States and the Supreme Court, the idea of what is offensive, you know, what is vulgar, these things, the word offensive itself has been legally argued to be subjective in a lot of ways.
Right.
In the eyes of, well, I know it when I see it. I believe there's actual legal cases where judges have said, well, it is what it is. I know it when I see it. Well, how do you call that objective then? It's offensive, but how is it objective? And that standard and idea that, well, what we're going to try to do is say, well, it's got to be something where almost in as sensitive a way as possible, you have to really read the room of the university, determine what the overwhelming majority of the university would feel about this. I think, yeah, it's a good thing you bring up, that's going to be a tricky thing for universities to guideline out going forward.
Yeah.
Donna, was there something you want to add to that? Or?
Yeah, thank you. I agree wholeheartedly with Suzanne and the conversation so far about the definition change being pretty significant. I think we've also talked about just concerns related to, you know, where the rules are placing the emphasis for schools, and just a concern that some of what's being prescribed for schools to adhere to are things that are less victim-centered and less trauma-informed, whether it's requiring schools to have a live hearing with a cross-examination of students, or it's the process that they're going to use to determine what types of supports that they can implement, and really not allowing schools to implement supports that could be perceived as, you know, being punitive or disciplinary or creating a burden for any party involved. So I think for me, when I first read through, and I'm still making my way through that 2,000-page document, but when I first read through the preamble and really got into the nitty-gritty of some of the prescribed changes that schools cannot opt to use or not, they have to use these new procedures. I just was struck by sort of many of them do not seem trauma informed, and I worry that there could be a chilling effect.
One of the changes that I know Suzanne and Donna and I had talked about as well as we were prepping for today was around who students can make reports to and sort of what they anticipate might happen as a result of making that report. So under previous guidelines, just about anybody with any authority on a college campus was then required to, you know, if a student disclosed to them that they had experienced sexual harassment or sexual assault on campus, if a student made that disclosure to them, they were then required to report that up the chain to the Title IX coordinator and other folks with authority. And now under the new guidelines, the number of people that are sort of required to forward those reports has been more limited. And so, you know, a student could make a disclosure to a professor with an expectation that that professor would then do something with that disclosure, do something with that report. And that might never happen because that professor may no longer have that obligation to, you know, to forward that complaint up to the Title IX coordinator or whatever. So, you know, what we could see is that there might be multiple people on campus that have heard disclosures that where that information never gets carried, you know, sort of to the top, so to speak. And so that's somewhat concerning too, especially when we're talking about guidance that's really around changing the culture of campuses and making campuses a place where harassment and discrimination isn't accepted. And so, you know, sort of knowing that this is the kind of thing that could happen where you could have multiple students experiencing sexual violence, but knowing that there's no obligation to carry that information on is somewhat concerning. I do think there's a flip side to that because I do think that sometimes there are students that want to disclose to a trusted professor or an RA or somebody that they have that kind of close relationship with, and they just want to be able to talk through their options and they just want to seek some support, that it's not their intent to have that information passed along. And so in some regards, I could see some benefits to that. But again, you know, we have to look at that broader picture and think about, you know, then what does that mean for the culture of that campus? If, you know, sort of there's no one person necessarily that's going to be collecting all of this information.
So looking at that, one of the things that I noticed, and this kind of, I think, speaks to you know, get a better idea of like what we mean about being trauma informed and understanding that as it is a federal guideline, obviously it's going to have to be as neutral, objective, equal-sided as possible. There are still, that having been said, ways you can go about that recognize the effects of trauma on the parties involved. And so to give an example, and this was sort of people on the outside might not consider it the biggest change, but bothered me, and I think kind of goes into the idea of trauma informed, is Title IX went from recognizing that if someone was a victim of sexual assault, sexual harassment, sexual violence, and they made a claim, they were recognized as a reporting party. And whoever they were making the report about was the responding party. The person now making that claim is the complainant. That's what they're called, a complainant. And speaking of trauma informed, to have a victim identified in a legal form or in a procedure as a complainant is sometimes enough for that person to decide, you know what, I don't want to go forward anymore. I don't want to be known as a complainant. I don't want to be seen as I am making a complaint. So even just that wording and that title can have an effect moving forward as far as making sure that we're doing what we can for victims. Were there any other things that you noticed that you wanted to address or talk about just kind of in general before we get into some of the more specifics here?
Well, I think in agreement to what you just said, in general, the policy or the rule kind of changes the or elevates to some degree the nature of the proceeding, because now what's supposed to be a campus disciplinary proceeding is looking more like some type of quasi judicial proceeding. Whereas if the survivor wanted to file criminal charges and have that type of case, they can do that. And it doesn't need to be the same thing happening in the school disciplinary proceeding. So the fact that we brought that into the school disciplinary proceeding kind of takes away many of the options that a survivor could have on campus, who maybe just doesn't want to take it that far, but wants some recognition, wants to be safe at school. We've kind of removed those options where now, even if that's all you want, then you've got to go through these strict procedures and you're going to be cross-examined and things like that. We've made it into a judicial proceeding on campus, and with no requirement that the school is really even qualified to do that. So I think it's gonna be a lot harder.
I just want to echo what Suzanne was saying. Like, when I think about the idea of cross-examinations during these hearings, especially live cross-examinations, it obviously just brings to mind a courtroom. And I think that will really be a huge deterrent for a lot of students, just to know that they even have to be in the same room with the person that caused them harm, I think would be enough to make a lot of people not want to move forward.
Just to add to that, also, schools will now have an option to choose the standard of evidence that they apply. The past guidance really encouraged schools to use the preponderance of the evidence standard, which has been upheld in civil matters and is commonly the standard that they use to adjudicate other student misconduct. And so now the rule change allows them to select a different standard and a higher standard, which is clear and convincing, only to apply to sexual misconduct cases on the campus. So I think it goes along with the concerns Suzanne and Karen are bringing about it feeling more and more like a formal criminal proceeding, as opposed to educating students and hopefully helping to educate students to prevent further harm on their college campuses.
And you mentioned the standard preponderance of the evidence. There's two standards that generally you see when you see situations like this. One is preponderance of the evidence, and one is clear and convincing. And preponderance of the evidence, in just the most basic sense, it basically means over 50%. Just that it's more than likely. So if you think about it like in a percentage, it's plus 50%. That's just the standard you need to meet. Clear and convincing is obviously much higher than that. It's not just a benefit of the doubt or a simple majority. One of the things that I noticed that has been brought up before is, well, universities they can decide which one they want to use, and ideally, looking at it, you could say, well, giving the university the choice, well, if they want to stay to the preponderance of the evidence, that would be within their right. They don't have to go up to the next higher level if they don't choose to. There's one caveat to that, which is if it's a university, say a public university, and they have a union, or they have some form of a contract with any of their employees, and that contract uses the clear and convincing standard for termination. So in other words, let's say you have a university and it's a union university, and in that contract with the union, the collective bargaining agreement, it says, well, if an employee is going to be dismissed based on sexual harassment or sexual misconduct, it has to be clear and convincing. Title IX now says, well, that's the standard you have to use, period, across the board, for sexual harassment, for sexual misconduct. Which, again, I hesitate, and I'm really going to try to do what I can to not use political ideas in this, because technically, legally speaking, there should be no politics involved in this. But that having been said, people. The law itself and the regulations may not be political, but people are political. And people tend to take their ethics and their emotions, and their politics reflect that. So they're going to have a moral or an ethical response to these things, and those are probably going to reflect their political ideas on this too. So needless to say, you go online right now, Title IX is either the changes that have happened now are the greatest thing in the world, or they're cause for concern, and it's too foolish to think that there aren't political lines in that as well. But taking that aside, it is important to understand that if you're a university and you're looking at this and trying to decide, well, you know, which standard do we get to use? The answer is, well, what standard have you already been using when it comes to like sexual misconduct and sexual harassment? Because that's the standard you're going to have to apply now. You can't treat students one way and your employees differently. So why do you think the changes occurred? Not everybody all at once. And I'll just say the reason why I put this in is it's not just a question that I've gotten from some people that have looked to me for the answers, which you know, this is heavy is the burden, right? But being an ethics and philosophy teacher, you always have to look at the why of these things, and that can be tricky. But as you mentioned, as we've said before, this is a 2,000-page document. The reality is, as I'm holding in my hand here, from page 208 to page 233 is the actual quote Title IX law. It's 25 pages of a 2,000-some page document. The other 2,000 pages are the footnotes and the why behind all of this. So clearly, it's something that they felt needed to be addressed. Why do you think the changes occurred?
Well, I think in my effort to think the best, I have to say, as it's written, there seems to be some desire or the need to kind of fulfill this idea of fundamental fairness, that people honestly thought that the procedure as it previously was unfair. I'm not saying that I agree with that, but I think that some of that does play into it. That this idea that offenders or people who were accused were not receiving fair treatment, I think plays a big part in the changes. I also think a lot of it has to do with liability, and universities themselves and their concerns about the financial liability, and the fact that with so much awareness arising within communities with the Me Too movement and things like that, people being more likely to speak out, then that fear of liability, I think, plays into the idea of, hey, we need to do something to protect ourselves. I'm hoping that that won't be bottom line, and that universities will still adhere to the ideas that they need to create safe learning communities. But I think that those are elements that, you know, dollars and cents, unfortunately, are always big elements that play into our standards.
And certainly some of the newer phrasing and some of the new terminology that you see in these particular changes, again, I don't think you're being cynical at all. It's in there, it's in the writing. It is reflective of narrowing down, as Karen mentioned before, even just narrowing down the people within the university that have the ability to take the report forward. It pretty much, the standard prior to the changes was essentially whoever the specific term, obviously since it's been changed, is kind of been lost to it. But if you were an official authority and you were privy to a report, you had the ability, nay, the right to report that and to carry the report further. It's been changed to, and I was trying to find the terminology, but the terminology is anyone who has the ability to enforce a punishment, which, I as an adjunct professor at Gannon University, if someone discloses to me in my classroom, in prior terminology, I was someone that I had the ability, I had the right, I had the need to carry that report forward. If one of my students discloses to me they were sexually assaulted. Now, I don't, in the university of where I teach as an adjunct, I don't have the ability to adjudicate and to enforce a punishment. So what does that mean for me? It means I can carry it forward if I want to, but I'm not required to, and I don't have to. I think for a lot of educators, you may know the general idea of like mandate reporting when it comes to child abuse. If you think of that general idea, but now instead of talking about mandate reporting of child abuse, it's you've had sexual assault or sexual harassment disclosed to you. Well, you're not that form of mandate reporter anymore unless you have the ability to, lack of a better term, do something about it at that university.
Right, and I think, Brian, like, as the rule stands now, like even if someone like yourself decided to, hey, I heard this report, I'm gonna go and move this forward, that doesn't move it forward unless the complainant themselves decides that they're gonna do a written report and submit that to the Title IX office or the person who the school has designated. The school does not have to act. So.
And taking that as it is, and getting into the why, is there a devil's advocate? I don't want to say the other side of the coin, we'll say. Pardon that term. But I don't want to apply the devil on one side of this or the other, but is there a way to say that because now we've reduced the number of people that are required to disclose this and move this forward, could that be seen as possibly victim supportive, and that we're not forcing a victim to go any further than they have to or want to?
Yeah. Oh.
Go ahead, Karen.
Yeah, I think that can definitely be the case, and I alluded to that a little bit earlier in our conversation, because I do think that there are many times students maybe would want to talk to a trusted confidant who might also happen to be a professor or another employee on campus. And in the past, that person, and even until August, that person was required to then forward that along to the next level for investigation and that sort of thing, and that would be without the student's choice necessarily. And as an adjunct, I had my speech in place for if I sort of got the sense that a student was going to disclose. It was that I'm sorry to interrupt you, but I want to make sure that you understand that if you tell me anything related to this kind of conduct, I'm going to have to report it. Sort of shutting that conversation down before it happened, which, we know for survivors, it can take a lot for them to sort of feel comfortable to disclose to anybody. And that disclosure can be a really important first step in healing. And so to be in the position of having to shut someone down when they're about to do that is a really difficult spot. And I think it puts survivors sometimes in difficult spots as well. That being said, I think it's the right thing to do in order to make sure that somebody understands all of their options and understands, what's going to happen next. But I do think that there's potentially a good side in that this allows students to confide in people that they trust, and still, hopefully, universities and colleges and all post-secondary education institutions will continue to educate and train staff about how to receive disclosures, about what students' options are, both on campus and within the community, because of course we want to make sure that students are connected with rape crisis programs and other supportive services that they may need. So I do think that there's, potential for some good to come out of that. But again, it requires colleges and universities and individuals to take responsibility for continuing to educate themselves about how to receive those disclosures, and then what to do now under the current or under the new guidance. It's not current yet. Under the new guidance, what those options might be.
Yeah, it's important. Like when you mentioned that, and I always think, God, I don't want to shut anybody down either, obviously, with when we're talking about things like mandate reporting or whatever. But the reason why it is important for anyone who might be listening, if you find yourself in one of these positions where you're a mandate reporter or you're someone on campus that someone might come up to or disclose to, the reason why we were always having to be prepared to tell them right off the bat, okay, this might fall into Title IX, this might fall into mandate reporting. You need to know I'm going to tell somebody is you want to be, again, trauma and care informed, and you want that person to understand, I'm here for you. I'm going to do what I can for you. However, the nature of me being able to do that means if what you tell me falls into a particular area of knowledge, I have to do what I have to do for your safety and for you. And you don't ever want to be in a situation where someone is misunderstood on that idea and has a level of trust that just isn't real, because then you are running into a situation where you may traumatize someone that's come forward to you and thought, well, I'm telling Brian, no one else will ever know. It's cool, it's good, I'm going to tell them, and that's it. And then they feel a particular way, and then there's that knocking on the door of someone coming forward. And now, we've unfortunately seen situations where if that wasn't properly expressed, now the investigation isn't, or the reporting or discovery isn't going any further because the person just shuts down because they feel like their trust has been violated. Brian said one thing and did another, and you don't ever want to be in that situation. So I would certainly say to anybody listening here, if you find yourself working in an area that's an educational field on any level, understand what your standards are and what your requirement is when it comes to these things, so that you can do what's best for the students that are in your life. So, good.
Oh, sorry, Brian. I was just going to add that I do think, in echoing Suzanne's desire to look for the ideal or assume the best, that it is true that I think many victims will have more autonomy over what happens to the information they share. I think some of the guidance too can be helpful, potentially, in clarifying what schools are obligated to do and distinguishing between a response and an investigation. I know as a former Title IX coordinator, it was a very confusing process, especially if you didn't have a victim survivor who wanted a formal procedure. Then you were in a place of repeatedly trying to contact them, which could be invasive and re-traumatizing. There wasn't really a clear process that distinguished between responding with supportive measures and referrals and help versus a formal investigation with a possible finding and possible sanctions. And so the cases where there was a victim survivor who wanted that formal investigation to go forward, it was less of a confusing process. But in those instances where, a faculty member moved a report up the chain of command to the Title IX office, but there was no victim willing to talk to you, yet you were still responsible for potentially investigating something without enough information and certainly without the consent of the survivor, that was a very difficult spot to be in. So in playing devil's advocate or trying to look for some of the silver lining, I think some of the guidance that really distinguishes between these two paths might be helpful, and it might give victims more autonomy. But might is the key word. I think we won't know until we see how students are impacted by this and how survivors are impacted.
Moving to that idea and everything, one of the things that the new implementation, the new changes and everything have sort of hatched out is the idea of live hearing and cross-examination. And I just wanted to kind of get your ideas specifically on those, why you think they're happening, advantages, disadvantages, just a general aspect of that. Because I know just in the going online, like even if you just do a Google search of Title IX changes, the overwhelming majority of news articles that reported about this, higher education websites that put forward about this, that was one of the first things that almost all these articles sort of covered, was the idea of, okay, well, now we got live hearing, now we have cross-examination. So looking at it in the prospect of everything else, how do you take it, and what do you see as that being moving forward?
I think that the possibilities of that just getting really ugly are very strong. I don't know, I'm really not certain as to why that was considered to be a good idea or the way to go. But certainly I can think of many other ways that it could have been done to get the same type of information, but I'm not sure why that was considered the preferred process. But I think since it's important for survivors to know that in selecting their advisor of choice, they can select an attorney. And if they are aware that the offender is represented by an attorney, then I would suggest that they seriously consider selecting an attorney as an advisor of choice. Because if not, they're just going to be mismatched. Like the attorney is going to be so used to doing cross-examination in a court proceeding, and then if you have your advisors, like one of your other professors who maybe has had no training in that or never done that, you're going to be at a disadvantage. So if that is the case, then I would strongly suggest that they consider selecting an attorney as their advisor of choice. And like I said earlier, that is a service that the PCAR project does provide. So, feel free to make referrals to us for things of that nature. And then the other thing I want to point out is that although the cross-examination is going to be allowed, it is not required. So already I am aware of some attorneys in private practice who have, pending cases, and they are doing agreements with the other side to waive the cross-examination. So that is, an option of something else that can be done. But yeah, that could be, the trauma involved with that could be really almost as, I don't want to say as painful as the actual event, but the potential is there that could be as traumatizing as the initial event. So it's really something to take into consideration as to how that's going to be managed. And I'm not even sure like how soon the survivor would know who the other person's advisor of choice is, like who's going to be cross-examining them. Mm-hmm. So without knowing like how soon they can get that knowledge, it's very tricky.
It seems like the general idea, and I don't know if Karen or Donna, if you have something to different to this, it seems to me, looking at it in the way it is, the idea is once the notice has occurred that, okay, well, this is going to proceed to a lot what would be called or considered the live hearing. It seems that it's that 10-day period is the standard that's been set to like to use the other legal use. That would be the discovery period where information would be shared, the back and forth would be going, the knowledge would be set as far as, okay, who's representing who's advocating for who, what would be brought up. I'm glad you mentioned that, because I know that was one of the things also I very viscerally and emotionally reacted to, is the idea of cross-examination. But taking it as it is and the potential for, okay, let's still make this work as fairly as possible. The Title IX does make clear that this doesn't open the floodgates per se as far as cross-examination. The standards of what can be asked and what can be brought up haven't changed in this new one. So things like previous sexual history and things like that, they cannot be brought up except in, and if I'm understanding this correctly, except in the sense of attempting to prove that it wasn't the respondent who committed the act. So in other words, if through cross-examination you can show that I'm going to ask about a previous sexual encounter, but it's just to show that this wasn't the person who did it, which, I don't know why you need to put that in there. It seems to be like it was pretty just exculpatory as it is. And then the idea of this concept of to try to show consent, but that alarms me because unfortunately one of the reasons why we've seen previous sexual history prior to this not being allowed to be brought up in cross-examination is the idea that your previous sexual history has nothing to do with whether you consented in this moment to what occurred. So that was when I saw that particular, I was like, well, again, it doesn't have to go down that road, but you are creating the possibility of it. Like you said, that potential. And it's going to be on the universities and the people involved to know, look, yes, there's cross-examination, but there's still standards to cross-examination you still have to apply. Are they going to know that, or are they just going to trust one of the parties' attorneys to tell them what they're allowed to do? Get the tail wagging the dog in that case.
I think too, getting to the why of this live hearing and cross-examination, I know when they put out the proposed rules for public comment, there was a lengthy analysis of the need for live hearings and cross-examination to really assess the credibility of the evidence being submitted and shared. And I think, when we look at the fundamental fairness that we're hoping is the catalyst for many of these changes, that rests on the training and the knowledge of the school, the people receiving the reports, the decision makers that will be assessing credibility and evidence. And we know whether it's a campus proceeding or a criminal courtroom, that things are usually stacked against victims of sexual violence. And people don't usually fully understand the counterintuitive ways that victims behave during an assault, after an assault. And so the concern here is that if they're doing these procedures to better assess quote unquote credibility of a victim's statement or the respondent's statement for that matter, the concern is that things are usually stacked against the victim. There isn't usually a lot of evidence. There's bias, there's victim blaming that is still very strong in our society. As much as we've made progress, that gets infiltrated whether they're on a college campus or in a criminal courtroom. So it's of great concern, and I'm so grateful for Suzanne's team and work and that strong message that attorneys are available to represent victims to help them navigate these new changes.
And just with the dynamics alone of the way these assaults are playing out on the college campus, we're just from the research and the statistics, we're not talking about like large numbers of people being attacked by strangers. We're talking about survivors and the person who lives down the hall from them and people they're in class with and people that they know. So the idea of them now, going to battle against each other in this format it's going to be very challenging. And then to be able to present that in a manner that with a clear and convincing evidence standard that's going to be able to show that, hey, yes, I know him. Yes, I thought he was my friend. But yeah, I told him 3 times, don't come in my room. And then one time I said, okay, come in my room. This the dynamics of that in the context of how the assaults are occurring on the college campus. It just doesn't seem like it's the answer for the problem that they're facing.
And this is why, and maybe you can make this clearer. I always try try to explain from people who've asked me before Title IX, and they were in the same boat that I was in. Oh, Title IX, that's the sports law. Oh, that's the thing about the sports and the equality in sports. Why all of a sudden is it being, and I've had this term used by people I know, why is it being weaponized? Why is it being weaponized and used as a weapon for sexual assault now? What I've told them is, well, you can't say it's weaponized because it's a law and it was beyond just sports. It basically says you can't discriminate based on gender. If you're getting federal funds, you can't do that on your campus. And they go, well, then how did it wind up in sexual assault? Is it true, or would it be a fair statement to make that what we saw prior to Title IX being utilized in the way it was that sexual assaults and the investigation of the crime of sexual assaults and sexual violence on college campuses was being treated and processed differently than other crimes on campus? And because the number of victims of sexual assault happened to be very predominantly female, you saw female victims of sexual violence not being given the same options and legal proceedings and treatment as if they were assaulted or victimized in a different way on campus?
I don't know if this is answering exactly what you're asking, Brian, but I think for people who knew Title IX as applying only to athletics, I think it's helpful to take a step back and look at what the actual Title IX law says, and then how it gets implemented is really through the federal Department of Education, through guidance documents. So from the early 1970s, the law didn't really get specific. The law didn't say, this is how you need to comply. These are the policies you need to have in place. This is how you need to prevent sex discrimination from happening. It really was a broad law that prohibited discrimination. And then it was up to the Department of Education to tell schools, how do you do this? And so those are those guidance documents that came out of the Federal Department of Education from the early 1970s. There have been guidance documents under various administrations, but it wasn't until 2011 under the Obama administration that there was this unprecedented call to action and telling schools, you are not taking sexual violence seriously enough. And let us remind you, dear colleague, that one instance of sexual violence is a form of sex discrimination. And here is a set of guidance documents that we are issuing to you in your compliance with this federal law. And so I think perhaps before that guidance document, sexual assault was not being taken as seriously as it should have been. Campuses were reporting 0. And we know there's no campus free from sexual harm. So I think it was this call to action that really then elevated sexual assault as a form of sex discrimination. But all along, Title IX applied to those acts. It's just that it wasn't really being elevated to the degree that was needed, in my humble opinion.
And it's one of the reasons why when like in particular, one person asked me, well, why are they, like, I understand what Title IX is, I understand what sexual violence and all that is. Why did they use Title IX for this? And what I said was, you saw the situation where if you were a victim of sexual violence, you were not being given the same avenues and procedures of treatment that you would if you were a victim of any other crime on campus. So if someone, breaks into my car, I got one system that was granted me as a victim of that crime. If you were a victim of sexual violence, it was like you got treated over here in this other form of procedure and everything like that. And so I think when the movement was made to apply Title IX to sexual violence, it was for other reasons to also combat that, to say you can't take a victim of this particular type of crime and put them through this form of procedure that will lead them to a situation where they're still going to have to go to the same class, to the same dorm as the person that just victimized them. Whereas if you had somebody, if someone came up and like physically assaulted me, got into a fight with me, or they broke into my car, or they robbed me, if I go to the university and I tell them this is what happened to me, this is the person that I say I did it, the school is going to go through their procedure of adjudicating that. But in the meantime, they're not coming to my biology class. They're not going to be in the same dorm room as me. I'm going to get a different housing or whatever for my safety away from them. You just weren't seeing that when it came to sexual violence or sexual assault claims. Correct?
So one of the things that I've just been thinking about as we've been talking, and Donna and Suzanne, please chime in. Like Donna, I started doing sexual violence prevention and advocacy work back in college and things like that. And I know we feel like there hasn't been enough change, and there certainly hasn't, but there's been a lot of change since I started doing that work many moons ago. And I think about, when I was in college, how so much of what we would now call out as rape and sexual assault was behavior that was just kind of accepted and maybe not recognized for the violent acts that they were. And so I think there was sort of this culture of silence, but also just, I'm not sure students understood what was happening or didn't define it in the same kinds of ways. So I also think that part of the changes that we're seeing, part of the advocacy that we're seeing, the resistance that we're seeing, is that people are redefining their experiences, both as survivors of those experiences and frankly, potentially people that perpetrated against others, but just didn't recognize or define it in that way. And so I think we are really, kind of seeing an evolution with all of that as a result of all the advocacy and the Me Too movement and, the huge outpouring of support and advocacy around campus sexual assault in particular over the last number of years. So I do think that we're now understanding things differently and defining them. And as a result, there's going to be sort of great support for that, but then also I think some opposition to that as well.
One of the things I took away from one of my Title IX trainings that I went to prior to these new changes and everything, and to their credit, the particular training I went to, they couldn't, because it was a training, they couldn't say, here's what we're going to train you on until the change came. But they were pretty good at giving people kind of the heads up of what was expected to be changed. And they got a good chunk of it right. But one of the things they stressed was what you mentioned, Karen, is that don't get it confused. Like, the culture and the attitude towards all of this has really changed. And while, depending on these standards and these new procedures and everything, while they could create the ability for a university or a school of higher education to, quote, go back to the old way, you're seeing a lot of general attitude, at least from my perspective, of nobody wants to be that university. Nobody wants to be the one that goes, okay, let's go back to, for lack of a better term, let's go back to the old school way of treating these. That ship may have sailed. That having been said, though, there does seem to be the potential for liberties to be taken depending on the parties involved and the interest of the school. But one of the things I also want to mention that was one of the first sort of oppositions that I kind of noticed from areas of higher education was you had all these schools, as Donna mentioned, that were reporting zero assaults, zero sexual violence on campus because of the way they would report it and the way they would deal with it. It wasn't a lie, but it wasn't the truth. Title IX pulled back that, the dear colleague in those standards pulled back that and didn't allow universities to have that. And you had this fear, I think, in a lot of campuses and a lot of major universities saying, well, now what? Now no one's going to want to come here because now we have to report it. And I don't know, maybe I'm looking at the world through a bit of rose-colored glasses, but what you actually saw in a lot of cultures were parents and families and communities going, I'd rather you report to me exactly what's going on, and I'll send my kid to a place where I know there were 8 assaults. You reported all 8 assaults. You adjudicated them. You did what you had to do for those 8 assaults. Then this university over here that's still reporting 0, and I don't know what's going to happen to my son or daughter, and what procedures are going to be there for them if they go to that university. So again, you know, it's the tricky thing when you see things like guidelines and laws and everything. Society and culture moves very fast, especially in this day and age with technology and everything. And it seems like it's progressing in a positive way. It can just take the law some time to catch up to that too, and hopefully not take a step backwards. So any other just kind of final thoughts or guidelines, if you were to give any message to parents, students, educators, you know, pick your audience and what you would say to them about this new Title IX going forward as a final thought.
My final thought for parents and students is similar to my original thought, and that is to know what the school's policy is. And that even if for one reason or another, your situation does not fall within the school's policy as being actionable under Title IX, just remember that that's only Title IX, and that you should review what are the other misconduct policies at the school, and is it possible that what happened to you could be adjudicated under another policy. Just because you got kicked out of the Title IX process does not mean that there is no process for what happened to you.
I would say if my audience was school administrators and trying to change their policies to become compliant with these new rules in August, I would encourage them to reach out to their local rape crisis center for partnering with them on policy development, prevention, and advocacy and services for victims. Like you're saying, Brian, there is momentum throughout Pennsylvania, and we've made so many important strides in prevention and advocacy. I would encourage schools to understand where their wiggle room is. There is a set of prescribed changes that they must adhere to, but then there's also some wiggle room, and PCAR is working on developing some resources on that. So I would encourage schools to keep doing the good work they're doing, find where the wiggle room is, choose the victim-centered, trauma-informed way to do that, and partner with their local rape crisis center in keeping the momentum and the good work going.
And I feel like I just want to underscore everything that Suzanne and Donna just said, because they summed it up beautifully. But absolutely, I mean, survivors have options. And I think that's such an important message, because so often people feel very alone and they feel like they don't know what to do or where to go. And it's so important to know that you do have options, and help is available, and healing is possible. And rape crisis centers are an awesome resource, not only for school administrators for all the reasons that Donna explained, but because they can provide free and confidential counseling to survivors. That you can reach out to your rape crisis center and ask all of these questions and not worry about who's going to find out about it or who's going to tell someone, you know. And so that's really, really important to know that that's available to survivors and loved ones and family members and friends who might have questions and want to know where to go next, or what they might be able to do. Because as Suzanne said, maybe Title IX isn't where you're going to find your relief, but you might have other options on campus, and you might have options off of campus where you can, you know, sort of seek that healing and that safety that you're looking for. Because we know that there is no one size fits all approach to responding. We know that every survivor is different and has different needs. So, you know, again, I really encourage that connection with the local rape crisis centers, and certainly the legal assistance project that Suzanne runs through PCAR is a great resource, particularly for survivors that maybe don't have access to legal representation in their own communities. And to know that that's available to survivors regardless of ability to pay, because I think that, you know, financial barriers can really be difficult for survivors, because, you know, they might know that the respondent has an attorney and they're thinking, well, I can't afford that for myself. But that help is available for free. And again, that help is confidential. So that's, I think for me, that's a really important final thought.
Absolutely. And I'm really glad, and this is like worked out so great, that at the end we're making it important to understand that, like, while the breadth and the attitude towards the Title IX and some of these changes, you know, adhere to that idea of Title IX in the way it applies to sexual crimes, sexual assault, sexual victimization on campus, that was the result of, because procedures weren't necessarily being utilized in the best way for victims of that crime, Title IX was almost, for lack of a better term, that last weapon, that last tool, that last law or device that a victim could use when the system wasn't being utilized properly in regard to that. That culture in a lot of ways, in a lot of places, has changed. And you're seeing a lot of universities just in general treat sexual assault, sexual violence, sexual misconduct, sexual harassment in such a way that there are a lot of options out there without Title IX itself. It's still there, but you might not just have to rely on Title IX. You might be able to directly go with that. One of the other things I would say, just in general, to anyone that finds themselves in the culture or in the community of higher education, is every school has its identity, has its mission statement, its tenets that it follows as a university. And you will rarely find a situation where the system doesn't try to allow you to express that mission statement in the best way possible in the interest of the students. And so, like I said, I was speaking with some religious affiliated universities, and they're attempting to take the idea of religious exemption, their mission statement, and use it in the best way with these new Title IX standards to protect victims and to empower them, and to make sure that if someone is victimized on this campus, whatever campus it may be, we are using our mission statement and the law to make sure they get what is best for them. And it's important to understand that, especially when it comes to things like, you know, sexual victimization, the barriers that the victim is going through are such that it's not unheard of that the full live hearing, cross-examination, utmost punishment is what the victim even really wants, or what they may feel they need. They may just want moved to a different place on campus. They might just want taken out of one class and put in a different one. They might just want to be able to be around a counselor and get the help. And these are all things that universities already have the tools and the ability to provide the victim. And this new Title IX doesn't change any of that. But at the end of the day, you want to make sure you're taking these changes, like, you know, Donna and Karen and Suzanne said, and applying them in a way that's best, you know, informed trauma and victim supported as well. Any other final thoughts? Well, I want to thank Karen and Suzanne and Donna, you know, very much for your time. I appreciate it. And I will make sure that when we post this on my organizations, it'll probably be our Facebook, I will send links to your organizations and information. I would say anybody listening to this, if you have any further questions, it's what we're here for. Please reach out. And, you know, we're a support group for you as well as any, you know, potential victims. So please, you know, do not be shy. We're all in this together. So, all right. Thank you, everybody. Be safe. Have a good rest of your Monday. I appreciate it. If anything else I can help out or anything, let me know.
Thank you.
Bye.
Bye-bye.
Bye.